Welcome to Epstein Becker Green's Employment Law This Week podcast. I'm George Whipple. The FTC still has not withdrawn the non-compete ban it attempted to enact during the previous administration. A district court blocked the controversial ban in 2024, and the FTC appealed. With President Trump assuming power in January and Republicans holding a 3-0 majority on the FTC, most observers expected the agency to withdraw its appeal. Instead, the FTC has asked the court to hold its appeal in abeyance for an additional 60 days to determine whether the commission should reconsider its defense of the rule. While this move is unusual, many still expect the agency to eventually dismiss its appeal and shelve the rule. We will report here on any new developments. Meanwhile, a new law in Florida has made the Sunshine State one of the most employer-friendly in the country for non-compete agreements. The Choice Act went into effect on July 1st, adding new flexibility for employers and robust remedies for non-compete enforcement in the state. Under the Act, non-compete agreements and garden leave for covered employees can extend for up to 4 years, longer than any other state with a specified time limit. The Act also makes it much easier for employers to get injunctive relief to enforce agreements. The Act applies to most employees earning at least twice the annual mean wage in the relevant county. SCOTUS to take up withdrawal liability. In the October term, the Supreme Court will hear a pension withdrawal liability case that could mean a difference of millions for employers in the country. The court will resolve a split between the D.C. and Second Circuits. The issue is whether pension plans can use actuarial assumptions adopted after the end of the plan year to determine withdrawal liability. Under the Second Circuit's decision, employers are locked into actuarial assumptions set by year-end. The D.C. Circuit allows plans to update assumptions after the fact, driving liability sharply up or down based on shifting interest rates. This decision could lead to millions in liability shifts for employers, and it's definitely one to watch this fall. That's it for this week. Thanks for listening, and we'll see you next time.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.